I think one of the first things you need to think about is whether you are buying the claim as a transaction in itself. So Mike had talked about the liquid market for claims and the expectation that you would be getting a distribution on account of that claim greater than what you paid for it. That has sort of one set of risks. Another sort of vertical, if you will, is if you are buying a claim for the purpose of getting control of the process, whether that's to control a plan, to control votes in a class that would provide for confirmation of a plan, and or if you're buying a claim for the purposes of, for example, a credit bid in a loan-to-own scenario, which is something we didn't really touch on very much. Starting with that second group, if you are buying a claim for the purposes of getting control of a process, one of the things that you need to be mindful of in the plan context is that you could have your claim vote designated. So stepping back, you need to do your due diligence and figure out whether the claim that you are buying is impaired. And I don't mean impaired in the sense that your recovery is not going to be 100 cents, but impaired in the sense that the seller or holder of the claim has done something that would give the debtor a cause of action against that creditor such that your claim isn't worth what you think it might be. That type of diligence could help you discover whether there's a risk of equitable subordination, which is a remedy in which the claim is subordinated not by contract but by equity. So that there's bad conduct, and the court says the penalty for that bad conduct is the claim drops to the bottom of the chain. I had mentioned earlier you could have your claim designated, and what that means is you could have your claim disallowed for voting purposes. In the context of a trade claim where you're buying the claim at 50 and hoping that you get a recovery of 70, one of the things you really need to be worried about is preference. And preferences are basically pre-petition transfers that a debtor may seek to recover and claw back under Section 547 of the Bankruptcy Code. And so why that's important is if there's a claim that's subject to a preference and avoidable recovery that's not paid back, then that claim is not allowed to share in recovery under a different code section. So you need to make sure that you have a remedy for that or a path that would allow you to receive the benefit of your bargain. Mike had talked about indemnities, sort of in a ripple effect, introduces the concept of counterparty risk. So it's not as simple and straightforward as it might seem on its face. And the last thing I will just touch on going back to claim infirmity is there are sort of two divergent views. One is what I'll call the KB Toys view, which is that the infirmity sort of attaches to the claim. So whoever holds the claim is subject to that infirmity. And then there's the Enron view, which drew a distinction between a sale of a claim and an assignment of a claim. I think that's a very fine, nuanced distinction, but the court was of the view that a sale severed the infirmity from the claim and the buyer.